Dear students, so welcome back to property law, industrial property law, sorry. That would be HOE 6065. It's under the laptop. So we were looking at trademarks, yeah, and also different ways in which a trademark which is registered can cease to be registered. And so again, well, we're looking at some of these issues that arise. And as we spoke or discussed last time, we're looking at certain sections and articles of the Trademarks Directive. So basically Article 16, then Articles 19, 20, and 21. And these cover this particular area in great detail. Now, it's very important to keep this in mind because, you apply for a trademark or your client applies for a trademark, the trademark gets registered, and you would think that's the end of the problems, but no, in life, problems never end. Well, if problems ended, if life was so problem free, then you wouldn't need lawyers. So, of course, we are looking at some of these issues from the viewpoint of how something that is registered can be lost. Now, remember, later in the coming lectures, I'll talk about infringement of the trademark and litigation in a court of law. And well, offense is the best form of defense. So many of these particular issues that we are discussing here also come up in the sense that if you are a defendant in a trial and the plaintiff claims that you have or your client has misused their trademark, then in that case, some of these are perfectly valid defenses. And what I'm trying to say here is that if somebody tells you that you are copying their trademark, which is registered, then you can always counter back by saying, well, your trademark should not have been registered because it has all these faults in it. So keep that in mind because a lot of these things play a role in a court of law as well. And where are we? We are in March right now, so I expect to finish trademarks soon. I've been really going through it in agonizing detail. Once that gets over, then we start looking at patents again in agonizing detail. So that should really cover everything. But I hope you understand that I'm looking at all of this from a very strictly legal angle, and we are exploring every possible aspect in this particular directive. And then of course that's the reason why a good trademark book is usually so thick, because there are also a lot of case laws and a lot of nuances that come up in the practice. And I've been trying to put up some newer case laws and also mentioning some of these interesting tidbits in the Moodle announcements. So I hope you keep tuned with all of this. All right. And now, well, we continue to the next phase, which would be under Article 20, and that deals with a very strange issue. It is the common name in the trade, which is that your trademark, which is registered, is now under threat because it has become a common name. And this comes under Article 20 of the Trademarks Directive. So, well, that's here. And trademark having become generic or misleading, indication as grounds for revocation. And so a trademark shall be liable to revocation if, after the date on which it was registered, as a result of acts or inactivity of the proprietor, it has become the common name in the trade for a product or service in respect of which it is registered, and B, as a result of the use made of it by the proprietor of the trademark or with the proprietor's consent. Now remember, I had this monologue about what consent can mean. In respect of the goods or services for which it is registered, it is liable to mislead the public, particularly as to the nature, quality, or geographical origin of those goods or services. Now, very often what happens here is, this is of course a question of fact, and so it has to be proven with affidavits, with expert witnesses, with questionnaires and surveys and things like that, if this matter ever gets legally disputed. But I can give you some very simplistic examples of this. One of these would be where you have a trademark like Google, and Google is a very good trademark, right? It is not based on any anything in the English language. It doesn't exist as such. It is a specially manufactured or coined trademark. It's different from Microsoft. Microsoft is still two words which exist in the English language, but they're joined together. And on the other hand, what you are looking at with Google is something that doesn't exist. So they have made a trade, made this word and coined it, or if it does exist, I don't think I've ever heard of it before. So now it's a very good trademark, and the risk is that such a good trademark can become a victim of its own popularity. Now, why do I say that? Well, very often you have the situation where a Google trademark, which is a proper noun, becomes a common noun or a verb or an adverb. And so these are all very tricky situations. So for example, when you say to somebody now, if you don't believe me, look online, search it online, or people say, if you don't believe me, Google it. Yeah, you see, Google it means now Google is becoming a verb. No, I Googled this particular thing and it shows that I'm correct and you are wrong. Now, in that situation, again, what you're referring to is that by conducting an act, which is Googling, you have verified certain information, or I have, discredited certain information. Now, all of this is a very tricky slope because on the one hand, it's very flattering for the Google company because everybody is using their trademark in such a everyday fashion, which basically means that they have conquered almost 90% of the market, and they're the most successful search engine in the world at present. But on the other hand, it also means that your trademark is getting diluted and it's becoming a common term. Next will be a situation where it enters in the dictionary, yeah, and it becomes a common word and a verb, and it's referred to with certain meanings or connotations. Then you have a movie, and in the movie somebody writes, oh, how I met somebody on Google, and then all of these things add up, and eventually you end up with a situation where a perfectly fine trademark gets lost because it now becomes common or generic. So these are often a lot of dangers that lurk for trademark owners. So they have to be very careful about how their trademark is represented in the print media, or online media, or in movies, or in the news, or in dictionaries. So very often a trademark lawyer has also to provide this service where they keep an eye out for such things, and if they find out any advertisement or any misleading notion whereby a trademark is being used as a common name or a common verb in a generic sense, then you have to send a legal notice to these people and tell them, please don't use my trademark or our client's trademark. Our client's trademark is registered and we have not given you permission to use this as a trademark. And this can be there in a lot of things. So for example, I was watching once with my wife, there's this this program where women have to choose a bridal gown, yeah, say yes to the dress, and there was this one guy in it, Randy something, and he's very lively and he's a star of the show, and he referred to himself as a Gucci whore, in a good way. What he meant was that he has a lot of Gucci stuff at home, and designer stuff, and everything that he wears is Gucci. Now, on the one hand, that sounds very interesting, yes, but on the other hand, of course, you're taking a perfectly fine, wonderful registered trademark and turning it into a sort of a common generic term, which is not what it's supposed to be. So you can see this also ties in very nicely with the concept of a dilution of a trademark. And these are all very important aspects because some of these trademarks can be worth millions, billions, what is Louis Vuitton if you take Louis Vuitton name away from them? I mean, then it becomes a big problem because that's their whole identity. So in this context, you have to really keep in mind all these things. And in fact, I think one of our students is also writing a thesis for a bachelor on trademarks used by fashion labels and fashion houses. And so, of course, um, you know on the one hand you may say, oh, this sounds so silly, I mean, the world has bigger problems than this. But on the other hand, you have to realize in a commercial sense, how valuable fashion trademarks are or fashion brands are. This is a multi-trillion euro industry. And especially in these times when a lot of problems are happening with the world, it's very important not to lose track of, um, not to sort of forget where we really are. And that is, as lawyers, it's our duty to help our clients to preserve their business and make sure that nothing goes wrong. Now, it's very interesting in the sense that when we talk about Article 20, that it says common name in the trade, yeah, for a product or service. Now, this is, of course, interesting because there's this Swedish case over here, Bjorn Kulla. And the twist over here was that the trademark, as it is presented, represented, marketed or sold to the consumer, end consumer, was not an issue, but rather there was this tendency amongst retailers. You see, there's a manufacturer, then there is a retailer, and then there is the consumer. All right. So the manufacturer makes certain products, and then these products are sold, for example, in Rimi, Maxima, Selver, Lidl, whatever these are. And now you are a consumer, end consumer, you go and buy the product from Rimi or from Selver. So for you, the only issue is, of course, what is the cost of this product, and why is it that in Rimi it is 10 cents cheaper, or in Selver there is a scheme and you're getting it at a different price. But what this particular case dealt with was a situation where the representatives from the retailers, so for example, Rimi, Maxima, Selver, Prisma, they were referring to goods of the manufacturer with a particular trademark in a different manner. And so now this becomes very interesting because Article 20 talks about trademarks becoming generic or misleading. But it doesn't only mean from a consumer's viewpoint, end consumer's viewpoint, but even from the people who are in the middle of the chain and who deal with these things. So of course you have to warn the infringers and you have to take action all the time. Now this also brings us to the concept of estoppel. And estoppel is a very British, English, Anglo-Saxon sort of term. And what it basically would mean is, as it says over here, Article 20, sub-article B, with consent. It's like you let somebody do something and you don't interfere. And now after 2 or 3 years, you wake up and you say, hey, don't do that. So the problem here is now it's either estoppel, ESTOPPEL, or lashes, LACHES. And both of these are very serious terms because as a lawyer, what question you are facing in a court of law or in a quasi tribunal is, why was your client sleeping for 2 years? Why didn't you take action immediately? Why did you let others think that by your inaction that their actions are condoned by you for some reason? Why would you not be actively protecting your trademark? So these are, of course, very important terms that you have to be careful about. And there are some examples over here. There was about daiquiri rum, then pina colada. Pina colada, of course, I bet a lot of you have drank it and or know about it. And then there are two types of pina colada. There is this non-alcoholic one and then the alcoholic one. And so, of course, there are all these aspects about it. But what's interesting to know is that this was actually a registered trademark, but it got lost because somehow the inactivity of the proprietor played a role over here. Now, this reminds me of a conversation I was having, and well, I asked my wife, she's Estonian, but she doesn't know much about this, but maybe some of the Finnish people may know more about this. It is this concept of, it's an old school thing, yeah, it's almost 35 years, so you may have to ask your parents or your wicked uncle especially about this. And the issue was, you have this Vana Tallinn, yeah, in Tallinn, in Estonia, that they sell this liquor, and it became quite popular apparently in Finland during the Soviet times. If you mixed it with some bubbling wine, yeah, or something, cheap champagne. If you mix these two together, then it was called Vikat, yeah, and Vikat or something, and then apparently it gave you quite a kick. Now again, you see what's happening here is your trademark is getting diluted, or a new trademark or a new form is getting created. Well, of course, this is a historical thing, and it doesn't really help us because in the Soviet time, the tendency towards trademarks was a bit different than in today's capitalist times. Then you have similarly issues. So historically, those of you who are aware of the Russian market, there's this thing called Champansky, and it's this Russianized Eastern version of champagne, which we all know is obviously incorrect because champagne comes from that part of France, and that's the grapes grow there. And so again, these are all instances where a perfectly good trademark can be lost because it becomes commonized. And of course, we have to keep in mind that 30-40 years ago things were very different with the Soviet Union, but now there is no such excuse for allowing such activities. So another aspect is marks which become misleading, and again Article 20 deals with the same issue here. Remember, it says trademark becoming generic or misleading. So what is misleading now? Well, in Article 4 we have seen that certain trademarks should not be registered if they are outlining the geographical origin or something very intimate about the trademark and the product or the service. And so when we look at this over here, well, marks which may have become misleading, we have to be careful about the issue that arises in this regard. But let me just see this. Is there an issue with the notes? So we are looking, for example, here. It's just that the law has changed, and so of course we have to be very careful about this. Yeah, well, okay, it's been corrected in the notes, so everything is fine. Yeah, Article 4, Article 20. Okay, and a lot of these things, of course, also play a role from a consumer's perspective. So when you're looking at a consumer, again, average consumer, average person, average intelligence, imperfect recollection. So all of these are there. The main thing what the court would be looking at, or in this case a tribunal, would be whether there's a real risk of the economic behavior of the consumer being affected, and whether this actual deceit or sufficiently serious risk will cause a customer or a consumer to be misled. So these are again matter of fact, a question of fact. Now this is again an old school way of looking at the law issue. One is a question of fact and the other is a question of law, and these are two very wide and different areas, and these play a big part in the evidence procedure or the law of evidence, as you may have in different countries. So what is a question of fact is very different from a question of law. A question of law is, well, if the law says that an Estonian national is somebody who has certain criteria. Yeah. What are the criteria? Well, if you're born in Estonia to Estonian parents, or one of your parents is Estonian, or if you're naturalized, then that's the question of law. So if the question of law is very simple, then the question is, are your parents Estonian passport holders? Yeah, if any one of them is, then it's a question of law and problem solved. Question of fact, of course, now this can be a bit of an issue sometimes. For example, does the sun rise in the east and set in the west? Yeah, well, that's settled law. I mean, you don't have to really have brains for that. Yes, so although it's a question of fact, the judge won't expect you to wake up in the morning at 5 o'clock and look on the horizon to see where the sun rises from. But another question of fact would be, well, continuing with this this citizenship problem, whether you say that your parents don't have Estonian passports or Finnish passports, but they were entitled to an Estonian passport. And I say now this gets messed up here. This is a question of fact now, and that plays very well over here as well. There was this other case, the Smirnoff trademarks case, very interesting. And you say, well, basically we all know Smirnoff, right? I mean, it's a vodka, it's a UK based company. They make beverages, they make alcohol drinks, and then Smirnoff is one of their flagship products. It's a vodka, and it's made in the UK. No questions about that. I think James Bond used to drink it sometimes. So okay, that's what it is. Now somebody woke up in 2006, and said that he is from the Smirnov family and they are Russians, and Smirnov was a well-known brand in Tsarist era. And then, of course, 1917 there was a revolution, and then all of these things got problematic. And there was a factory, there was a distillery, but then it got taken over by the state, and then it sort of just died out. And so some of the family members managed to escape out of Soviet Union, and now this person is claiming today that he is the original heir of the Smirnov family, and his family name is Smirnov, and now he wants the trademark back, and that the Smirnov company of UK is selling Smirnov vodka in a misleading manner, and people are assuming that it is an original Russian drink, which it obviously is not, because it's made in the UK. So when this matter went to court, as you can imagine, it's a matter of fact. Now it's a question of fact. And so the Smirnoff company of UK was able to prove that nobody remembers or cares what happened in the Tsarist time in the 18th and 19th centuries. And as far as their consumers are concerned, this is a British made vodka, and it's for consumers who are based in the UK or wherever else, and it's got nothing to do with any Russian connection. And nobody drinks Smirnoff thinking that they are drinking a Russian drink or something. That's not the case. And of course, those of you who like to drink, well, you can distinguish between Smirnoff and Nemirov. I think that's the one with some chili or something inside or whatever. So well, so these are of course interesting areas. Read more about it in the case law, and of course you'll get more ideas about this. So this sort of ends our look at Article 20 and Article 21 as well. So now we go on to another area, which would be the Section 5 of the Trademarks Directive. And now we are looking at trademarks as objects of property. For the exam, well, it'll be an open book exam. Obviously, the way coronavirus is, blazing out everywhere, I don't think we'll be having any exam in a classroom. So for the exam, I would advise you, of course, to also read up the articles and the trademark directive. And in these sort of exams, the main key here is to know where to look for what within that 2-hour period. And this is a 3-credit course, so you shouldn't really have any serious problems here. So assignments, trademarks as property, co-ownership, and licenses. Now, what is an assignment? Well, if you know from my transfer of property law course, so there's a sale or a mortgage or a lease or an exchange of a trademark of a product of a property, and in that same line of thought, your intellectual property is also property. So if you have a registered trademark, then of course you can transmit it, make it transmissible by assigning it, which is by sale. Testamentary disposition, which is you give it by a will or something, or operation of law. Operation of law would be anything. You have taken a loan, so you give this as security, your trademark, and now, well, you lose your trademark because of you have not been able to pay back the loan. So all of these things are perfectly possible, valid reasons, and there's no real distinction between a trademark or any other thing like a pen or whatever. These are movable, and of course trademarks, like all forms of intellectual property, are intangible. And then of course, that's the way it is. The only issue here is, of course, we're looking at registered trademarks. Can you sell an unregistered trademark? Well, it depends on who would want to buy it. There's always this issue here, because if it's registered, you have a certificate, it's in your name or your client's name. It says the class of goods or services, the description of the goods or services, the owner of the trademark, the proprietor, their details, their address, and it has a nice seal and stamp from the trademark office, and that is something that is already tradable as a community, as a commodity. Now, the reason why this becomes a bit complicated is because there is this old school way of looking at things and the new school way. All right, now historically we have to go back to, for example, in the UK, that would be the 1911 Act, I think, or something like that. So it was just before World War One, and then they had some reform in the 1930s, just before World War Two, and then after World War Two in the 1950s they had some changes and reform, and then in the 1990s they had a big act that came up. So if you look at it historically here, now I'm sorry I'm being all fuddy-duddy and talking about history here, but that's an interesting aspect as well. So earlier a trademark was seen as something that connects your product for service with your consumer. All right, so there's this direct link, and it's a very holy sort of a thing here. All right, what does that mean? Well, 100 years ago, if you had a jacket with an Italian trademark on it, you would expect that it was made in Italy by Italian tailors using Italian material. Yeah, I mean, that's how you would expect it. But that's not the case today, right? I mean, so you see this jacket here. I mean, it may belong to, I don't know, Zara or whoever, but if you look at the label, it says made in Bangladesh or made in Tunisia or made in Turkey. And should I get upset about it? Should I be like, what the hell? I wanted this to be made by some Spanish or Portuguese tailor or something, using cotton or whatever from grown in Spain. No, of course not. So of course, a lot of these issues do play a big role. It's the same with your iPhone. Do you think your iPhone is an American product or a Taiwanese product? Yeah, see, so a lot of consumer tastes have changed. The way society looks at products is changed, and so it also reflects on how the product or the service is now viewed. So for example, Lufthansa is a German company, Finnair is a Finnish company, but would you get upset if you go on a Finnair flight and you see a Chinese air hostess? No, or the pilot is from Lithuania. Is that something that would make you upset? Not anymore, right? So of course, what I'm trying to talk about over here is that the way a trademark is seen as a representation between the manufacturer or the service provider and the consumer, that has sort of changed a lot over the last 40 years. Call it globalization, call it whatever. And so this also, of course, plays a big role in some of these areas. Well, assignment has to be in writing. So that's one of the key takeaways from the most of the trademark, national trademark legislations that you have in place. And the register is not automatically updated, so you have to then apply to the trademark office and say that, well, the previous owner X has now sold it to Y, here's a deed of assignment or the sale agreement or whatever. And so of course such an agreement would now be covered also by contract law. It has to be between two parties or more who are eligible to contract. Well, the owner of the trademark and then the person who's buying, and they are of a certain age, or if it's in a context of a company or a natural or an unnatural person, separate legal entity or whatever you call it, then again in that context. And then it has to be for a particular price consideration. It has to be for a valid reason, and it has to be generally acceptable under the law. So you have these issues under the law of obligations or contract law that have to be covered. And now you have a trademark which is being assigned or sold in that sense. And of course, this again brings us to another issue that's very relevant here. Like, for example, this pen, it's movable property. Well, you would sell it as a whole, right? I mean, it doesn't make sense to sell it like this. This has a separate price and this has a separate price. Who the hell would do that? Why would they do that? But on the other hand, you could have a situation where, for example, Stockman. Now, we all know that Stockman has had some issues in Finland, in Helsinki, and now they had to restructure the whole business. And so what they did was they retained the trademark, but they have sold the building and the immovable properties and stuff. So you see what's happening here is your trademark is being separated from the physical parts of the business. Now, what we can see in trademark law is that you can always sell the whole trademark or you can sell a part of the trademark. Now, this is where it gets confusing. So, for example, let's say Stockman, now they have an office and business in Finland, Helsinki, and then they have this big giant house and departmental store in Estonia, in Tallinn. So they could always, say that, all right, the Stockman name, trademark, we will have it like this. Well, we will have a Stockman trademark registered in Finland, and we will sell it to a Russian business, for example. And then the Stockman business in Estonia, we will sell it to an Italian business. Yeah. So you see what's happening here. We're taking the same trademark and making some nice cuts and limitations in the context of territorial aspects, or you may say that, well, we have the trademark Euronics, and the physical stores which sell household stuff will be Euronics, and then that'll be owned by party X. And then the online stores that sell maybe just telecommunication material or certain type of goods, Euronics will be sold to somebody else, and they will be the owners. So now already you're seeing what an issue this is going to cause. This would never be possible here, right? But of course, in the context of a trademark, it's perfectly valid and legal to do. And this can, of course, cause a lot of issues. So you can see that in the notes here. Another big aspect is goodwill. Now, goodwill is this very crazy thing. It's very difficult to sort of explain. But, well, goodwill is, let's say there is this, this manufacturer of clothes, Burberry. All right. So Burberry makes jackets, coats, or whatever, and these sell for 15,000 euros, maybe even more. So why the hell do you want to buy a Burberry jacket? I mean, is it made of gold or does it have diamonds on it? No, you buy a Burberry jacket so that you can put the the collar up so that everybody can see that it has that pattern, and then those who know, they know that it's Burberry. Yeah, well, this person is loaded. And then those who don't know, well, you wouldn't really want to know about such people anyways, so who cares? All right. So it's a sort of a silent signaling of where I'm rich, I can wear a 15,000 euro jacket, but it's not like made of gold or something. It's just a informal subtle fashion statement that I'm making. And this is what goodwill is. Now, goodwill is a situation where you want to pay so much money for a product or a jacket, not because it's made of some amazing space age technology or something, but because it has a reputation, and you like that reputation. Now, what does this mean? Well, goodwill is protected in the sense that you don't find your Burberry jacket for sale in Prisma, all right? and you don't have Burberry jackets like worn by, fake Burberry jackets worn by babushkas in some tram or in a trolley bus. Yeah, that's how goodwill gets ruined. Goodwill is why every spring all these people go to Stockman to buy, toilet paper and stuff because it's on sale. They have this Hulude Paev or whatever they call them. And earlier I remember, they would have it first in Helsinki, and then they would have it in Tallinn, and then all these people from Estonia would go to Helsinki to buy them there, and then all these people from Finland would come to Tallinn to buy it, later also, because you had these good sales and stuff. And this is goodwill, and goodwill is of course worth a lot of money. So when you look at the Stockman business, again, coming to Stockman or Virukeskus, Kobamaya, whatever, there is one thing which is the property, it's the house, and it has so many windows and so many floors and so many employees and a cash flow, and all of those basic things that accountants see. And then there is the reputation. The reputation is what attracts customers. They go back to it. The reputation is what makes you go to eat at a McDonald's, even if you're in Taiwan, if you're in South Korea, if you're in Brazil, if you're in Rwanda, because you expect certain quality. Yeah, now this is goodwill, and of course goodwill costs money as well. Nothing in life is free. And so when you're selling something as a trademark, you could sell it with goodwill or without goodwill. So again, a classic example would be where Stockman, I'm just supposing this would be the most logical way of doing things. So you are on the board of Stockman, and now the business is not doing very well. So what do? You decide to sell the Stockman house to somebody, all right? And maybe you allow them to even have the trademark Stockman house, but not the goodwill. And so the goodwill stays with you, and so you are going to trade and rent out place from now the new owners of that building or the house, and then you're going to sell your products and offer your services. And so what you're doing here is you are cutting not only the trademark goodwill, but also you're looking at the trademark Stockman, but you're also keeping an eye out on the goodwill part. And this is of course a very tricky area, because it leads you to the question of valuation of a trademark. And valuation is awful, because even after all these years, there is no fixed accounting method to determine what is the value of a trademark. And if you look at a value or a goodwill, well, Nokia had a lot of value and a lot of goodwill. Where's that goodwill today? I mean, they still work, they still have a business, they still make money, they still have patents, they still do other things, but where's the goodwill gone? Every second phone used to be a Nokia phone, but that was before the smartphone era. So again, goodwill is something which is there today, it's not there tomorrow. And from a valuation point of view, that's a nightmare. And from a legal point of view, you have no idea what you're getting into anymore. So there is this Scandecor case, and again, interesting to see how goodwill is mentioned over here and referred to. Then there is also the Elizabeth Emanuel trademark case. And well, 40 minutes are turning up. So we have to stop here for now, because of this limitation of this phone apparently. But please read up the two cases that I've mentioned over here, and then I will continue again about this next time. And we'll also look at how your trademark valuation can get you in super trouble. This was one of the first major problems I had in my young legal career, and I hope you will find it enjoyable to hear. All right, because what doesn't kill you makes you stronger. Okay, so until then, thank you and have a good time. Bye.